we should proceed. Do we have to do the phone call and all that stuff? I suppose we do. Okay, so I'm going to call this meeting to order. And do we have any comments on an agenda item?
I think the first item on the agenda is the roll call, Trustee Brown. So I'm happy to help facilitate that if you want.
Okay, could you please?
Sure. Trustee Brown.
I'm here.
Trustee Wah.
Here.
Trustee Fellow.
Here.
Trustee Chen Lao.
Here.
Trustee Martin.
Here.
Trustee Silver.
Here.
Trustee Osterling. Absent.
No.
Just
Here.
Oh, there he is. I didn't see you. Pardon me. Thank you. And then student trustee Ramirez is not present. Okay. There we go. 7 out of 7 with 1 missing.
Thank you. So I didn't see an agenda. So do we actually have an agenda?
We do. The next item is the Pledge of Allegiance.
Okay, well, why don't we have our lovely trustee Anthony Fellow lead us into the Pledge of Allegiance.
Okay, if you'll place your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you very much, Dr. Fellow.
Welcome.
And what is next on the agenda, which I don't have?
Public comment. Public comment on non-agenda items.
So do we have any?
We do not.
Great. So is it that time now?
We are ready to start.
Okay, so we'd like to thank you, Todd, for joining us today and facilitating this study session for us. And we hope to be very much informed. Thank you. So now the floor is yours.
Well, thank you. Well, first I should introduce myself to the board members who don't know me. I'm not Warren Kinsler, who was originally scheduled to do this, who is your regular general counsel. I am his partner. I am also an expert in the Brown Act. And I recognize at least Trustee Way's name, and I think Trustee Osterling were around maybe about 7 years ago. And were you also around, President Brown? When
Yes, she
okay.
was.
Okay, and so you remember when I did a Brown Act training for the board, probably about 7 years ago now. And so some stuff has changed since then, and so it's always good to get an update. And in particular, you know, there's all the COVID related stuff that we've learned as we've gone along. And I think it's important for us, since we're still authorized to follow these requirements. We expect that perhaps we won't be as of June 15th when we supposedly come back to normal. But I think it's worth kind of reviewing where we've been during this extraordinary time and how it's affected our public meetings. And to be clear on what the rules have been, so that we certainly understand how they will apply in the next few months. And then as some of us were talking about before the meeting started, we could probably expect that some of these rules that give us more flexibility will be put into the Brown Act permanently in some form. And so I'll be interested to see how meetings change in the future because of the experience that we've all had doing remote meetings. All right, so one other note at the beginning is just a reminder that we are in open session, of course. And so a caution that I typically give to boards when we do a training is to make sure that although I encourage questions throughout the presentation, because I think that makes it more interesting for you as trustees participating in it, it's more of a workshop atmosphere, sometimes the questions that you have will be generated by particular situations that may have occurred in the past or in the present. And what we don't want to do is bring out into public session any questions that would involve a lawyer giving you advice, because that would be attorney-client privilege, and we'd want to make sure that that was done in closed session and not in public session. So just questions are okay, but make sure they're not particular to situations that may or may not have gone on in this district. So as long as we're all clear on that, you know, the Brown Act is a very complicated law, and to do a Brown Act training comprehensively would take probably 3 hours, and we have an hour and with 15 minutes of questions. So what you're going to be getting today is not everything that you need to know about the Brown Act, but it is a lot of the important stuff. And so if anyone ever wants to get a comprehensive view of all the provisions of the Brown Act, I believe the Community College League of California, if you click a few times, you'll in their training section, you'll come upon a Brown Act training in 8 modules that you can explore at your leisure, and yours truly is the trainer. So
I did it. It was good.
Great. Yeah. So that was that's about 5 years old now. So I think it was done in 2015. So if you've done that, be sure to pay attention here, and we'll cover a lot of the new stuff. Okay, so with that, I have asked for Alex from the Superintendent President's Office to share a screen with you. All right.
You're seeing that okay?
I'm seeing it great.
Great, thank you.
Okay, and so this training will be punctuated by me saying next. So let's do that now. Next. Okay. It's always important that we, you know, really focus in on what the intent of the Brown Act is, and it's that intent that always informs, you know, our decision making, I would say. And the rule, as stated in the Brown Act itself, is that public agencies in this state exist to aid in the conduct of the people's business. And so the intent of this law is that your actions be taken openly and that deliberations be conducted openly. Okay, so the public gets to see how the sausage is made, so to speak. The purposes of the Brown Act are to facilitate public participation. So the second aspect is that it's not just you as elected officials who are interacting with your staff and with each other, but the public also has a right to not only witness what you do, but also to provide you feedback, which may affect your decision making. Next. And so I remember when this happened, and so it's in the recent past, well, getting on now, over 15 years. But we did, in the state of California, we did pass a amendment to our Constitution, which didn't really add anything to the Brown Act, except for that it added the, I guess, the presumption, and it says, in light of the legislative and constitutional policies, the Brown Act has been liberally interpreted by the courts in favor of public participation and governmental transparency. So because there's such a strong public interest as reflected in our Constitution and our law, that when Brown Act cases go to court, the judges will tend to, if it's a gray area or a close call, they'll tend to rule in favor of transparency and openness. And we'll see that as we go through the presentation. We talk about some of the cases that have been decided and what and how that informs an understanding of what the law is. Because as with any law, the Brown Act isn't just a set of rules that are written down that you can see. It is also a series of decisions that have been made by our appellate courts and California Supreme Court that have interpreted what those rules and words mean in different situations. Next. Okay, going back to basics. This is the primary rule of the Brown Act, and about everything in the Brown Act is embedded in this one sentence, and it starts off the law, and it says all meetings, and of course each of these words is a code word that will have greater meaning as we explore it. So all meetings of a legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of that body except as otherwise provided in this chapter. So note that except as otherwise provided, that's your authorization for closed sessions. So there are written into the law the ability of a public agency to make decisions that are not open in public, but you have to follow the very strict requirements in the law. Okay, so maybe first we're going to get into the issue of what is a legislative body. And as we'll see in the next slide, and we won't go there quite yet, there are what we commonly think of as a legislative body, and then there are other entities which also need to comply with all the provisions of the Brown Act, and those are called the subsidiary bodies. And so subsidiary bodies of a local agency include committees. In particular, they include standing committees of a legislative body, and standing committees are those like budget committee. They are like facilities committee. They note that committees don't necessarily have to have a majority of the board on them to be subject to the Brown Act. Okay, it is. And so let's go to the next slide, and that'll give you the rest of the information. So as we said, as I was mentioning, a legislative body is the governing board of whether it's a school or a community college district or an insurance JPA amongst public agencies. It's the main governing body, but it's also all of these commissions, committees, whether they're permanent or temporary, decision-making or advisory, they're created by resolution or some other formal action of the legislative body. And so bottom line is when you, the community college board, create a smaller group, a committee, for instance, or anything else that it's your authority, you did it, then that body ends up being subject to the Brown Act, even if it doesn't have board members on it or doesn't have a quorum of the board. It is your committee, your subsidiary body, and so it just like the big board, those subunits of need to also comply with the Brown Act. Next. So there is an exception, and that is that committees that are appointed by the superintendent, president, or chancellor without any formal action of the board are not covered by the Act. Okay, and here's one of those cases I was talking about, Fraser versus Dixon Unified, that again says, hey, if you, the board, instigated the formation of the committee, in other words, if you told the superintendent president to do it, if you can't get around the Brown Act requirement through a technicality like that. And so the concept of formal action is broadly construed. And what are some other subsidiary bodies other than committees that apply in a community college setting? Anybody want to hazard a guess as to what some of the other bodies are that are covered by the Brown Act? How about your bond oversight committees? That would be one. Your any group that was created as part of, and we talked about this several years ago, the academic senate, the classified senate. There's other aspects of your shared governance structure. We're not going to go into detail this time as we did last time about that, but some of those groupings, not all, are also subject to the Brown Act, as is your associated student body and other. That basically covers the main ones. So next slide, please. Okay, so we went over the term, what does a legislative body mean? Now we're going to talk a bit about what does a meeting mean. And under the Brown Act, we used to think of meetings as being something that happened in a room where the board members are sitting usually on a dais and there's seats. And of course, nowadays we understand that meetings don't necessarily need to look like that. What the Brown Act is really concerned about is meetings that happen to happen in ways that are outside of the normal process. And so that's why a meeting, because of course the Brown Act is going to be trying to regulate and say when you can't, things that you can't do outside of a properly noticed public meeting. So it defines a meeting rather broadly. It says it's any congregation of a majority of the members of the legislative body. Okay, so for a 7-member board like yours, that's 4. And they're meeting at the same time and location. Okay, so if you physically were together outside of a properly noticed meeting, talking to each other, that would apply there. But it says including teleconference locations. Okay, and what you do at that meeting is you hear, discuss, deliberate, or take action on any item within the subject matter jurisdiction of the legislative body. And so what we're going to be particularly concerned about here are the words hear, discuss, or deliberate, right? Because most of the problems with Brown Act compliance happen outside of the traditional meeting and happen when trustees are discussing or even just hearing what their other trustees are thinking about issues within the subject matter jurisdiction of the board. And we can see some examples here. There's the traditional, there's, oh my goodness, looks like there's 5 trustees talking together. I hope they're not discussing business of the legislative body. But over here on the right, you see the text message there. Looks like a rather old phone, by the way. Might even be a pager, for goodness sake. But you can see that a lot of the new regulations in the Brown Act, and we'll certainly go over them in a minute, are designed to regulate the electronic environment. Okay, next. All right, what is a serial meeting? My oldest joke in the world here, it has nothing to do with the other kind of cereal. It is the different kind. It is a serial meeting is defined in the Brown Act as being a majority of the members of the legislative body shall not outside of a meeting authorized by this chapter use a series. Okay, so that's the serial we're talking about. It's a series of communications of any kind. Okay, so that can be by voice, it could be by cell phone, it could be by email, it could be by text, it could be through forms of social media, directly or through intermediaries. So you can't pass messages through other people to other trustees. And again, the problem arises when you discuss, deliberate, or take action on any item of business within the subject matter jurisdiction of the legislative body. And so this next series of slides is designed to help us understand the do's and don'ts of serial meetings. Next. Okay, so here we are. This is the 7-member Pasadena City College board. For the sake of these graphs, we're going to put a staff member. That could be the superintendent president. It could be another staff member. We're going to put that person in the middle because in some of these slides, that person is going to be involved in the discussion. And in this slide, that's not the case. This is your, I would say that the traditional serial meeting, which is where trustee number 1 talks to trustee number 2. Okay. The conversation could be something along the lines of, you're at a sporting event and you say, our coach really should, not be renewed in this position. We should get a new coach. And so trustee 1 says that to trustee 2. Trustee 2 goes to the refreshment stand and meets trustee 3 and says, you know what? I was talking to trustee number 1 and we really think the coach should be fired. And trustee 3 says, oh, that's a good idea. And then trustee 3 runs into trustee number 4 up in the bleachers and says, hey, do you think the coach should be fired? And at this point, this discussion has gone on between 4 trustees. And look at that, trustee number 1, trustee number 2, they had no idea that the conversation they started would make it to a majority of the board. And so that's really the danger about having discussions at all outside of an open and public meeting, which involve the business of the district, because that discussion, and of course we think of emails and texts and things that can be forwarded, right, can get out of control, right? So whenever you're having discussions outside of a board meeting between trustees and you're relying on the fact that there's less than 4 of you having that discussion, always make sure that the trustees that you've involved in that communication understand this can't go any further than us. Next. Okay, so here is the other kind of prohibited meeting, and it is called, this one is called polling the board, really, because that's what the staff member in this case is doing. And you can imagine this being, imagine this being the superintendent president, and the superintendent president wants to know, is there support for this agenda item that I'm going to put forward for action for the board? And because we'd hate to, put something forward and have the board vote against it. That wouldn't look very good for staff. So the staff member has a discussion with 4 of the trustees to make sure that there's majority support for the item. And it's the having of the discussion with the 4 trustees, each one individually, by the way, without any of the trustees necessarily knowing that discussion has happened with other trustees. So see, it says, even if the staff member doesn't communicate the comments or positions of the other members, it's enough that that person has, that the staff member has discovered through discussion how 4 board members feel about a particular item. And the example I just gave is a restrictive example. You can have prohibited meetings here that are called a hub and spokes serial meeting without it being so blatant as to say, would you support this particular item on the agenda? So I just want to make it clear that the example I gave was very sort of extreme. So yes, question.
Yes. So does this also apply to, let's say, if instead of the staff, it's a board chair or other trustees, so nobody can poll anybody in how they would vote?
Well, the problem ends up when you get to the 4th trustee, right? So in an example where it's not a staff member, right? So we can just have this, let's see, it's trustee number 1. Oh yeah, you can't see my finger pointing at it. So let's see, trustee number 1 polls trustee number 2, okay? And then trustee number 1 talks to trustee number 3, and trustee 1 then talks to trustee number 4, okay? Well, now there's 4 trustees involved, even though trustee number 1 has only had 3 discussions. So yes, the answer to your question is it could easily be a trustee in the middle of that of what we call a hub and spoke serial meeting. And if that person is in the middle, then only 3 trustees can be talked to, not 4, because the 4th one is you, or the person who's doing the talking. Okay, so So a trustee who wants to have a discussion about how other trustees feel about a particular action item can only talk to 2 others. Okay. Does that answer your question?
Yes, it does. Thank you.
So
Actually,
Todd, if
Yes.
the staff member is the superintendent, though, I mean, since the superintendent is elected, I'm not sure why does that violate the Brown Act?
Oh, because the Brown Act does not just apply to communications among trustees. It also applies to staff members, and we're going to see how that works. And I think the answer to your question will be in the next slide. But the Brown Act it wants to make sure, because see, the staff member in these cases, remember how the law said that board members can communicate through intermediaries, and that can be a problem. And so in this case, the staff member is acting as an intermediary. And also the staff member, there is something independently wrong, I would say, about a staff member who is engaged in the activity that is depicted here, because that staff member is collecting the opinions or the thinking of 4 board members and putting that thinking together. So even though the staff member isn't an elected official, the staff member is taking information from 4 board members and creating a serial meeting by putting that information together. So short answer to your question is that you can have a Brown Act violation that is initiated by a staff member that involves board members. It doesn't always have to start with board members. But I think this will become...
Todd, my other question then, my follow-up, then how is this enforced? How would you know?
Well, it's enforced through a common understanding of what the rules are, right?
It's enforced.
Yes.
It's enforced with the superintendent president doing everything she can not to violate this.
Yes. Yes.
So for example, Sandra, in this case, even if I knew how you were going to vote, how Berlinda was going to vote, or Tony was going to vote, because you chose to tell me, right? I wouldn't tell anybody.
Right. No, I'm not referring to staff as much as to when trustees, perhaps may poll other trustees. Then how is that? So there is so then you're kind of going on this common knowledge that it's not okay, and that it's, that you're gonna use either trustee 1, 2, or 3, or 4 would put a stop to that at that point.
Right. I think the answer to your question, Trustee Chen Law, is that the Brown Act mostly works by self-policing, by having well-informed trustees and a well-informed superintendent president who comply with the law and make sure that these things don't happen. And I will say that no institution operates, 100% of the time in compliance. So you're supposed to, and everybody desperately tries to do so, but there will be mistakes every once in a while. And there's a way to fix that. But it does, I would say, I always joke, there is no Brown Act police, but the best thing that there is a board that polices itself. and if there is a Brown Act violation, you recognize it and you do not repeat it the next time. Okay, next slide. All right, so this was a revision to the Brown Act. It's probably about 10 years old now, but it clarified what is known as the information gathering exception. And so what the Brown Act specifically says now is that an employee or official, So see how employees or officials are written into parts of the Brown Act. And so there's aspects of it that does regulate their conduct. It says an employee or official of a local agency may engage in separate conversations or communications outside of a meeting with members of a legislative body in order to answer questions or provide information regarding a matter within the jurisdiction of the agency. Okay, so let's pause there. So the Brown Act wants to make sure that you as trustees can get all the information you need to make informed decisions, and that you don't have to wait for a meeting in order to be able to get what you need. Because you need to study, the issues that come before the board and be prepared when the meeting happens. And so this allows that to happen. And the one restriction is it says that, and this was exactly what the superintendent president was saying, if that person, okay, the employee or official, does not communicate the comments or position of any other member to any of the other members of the legislative body. So you're not supposed to be talking about how you would vote on something, right? Because this is to ask questions and provide information. But if you happen to do so, then as long as the superintendent president or other employee and official doesn't communicate what you just said to any of the other members, then it's okay. And so that's what this one says. We do have a graph that will show what this looks like visually. So let's go to the next slide. So it often starts out like this, right? This is your Friday bulletin. This is information going out about something that's going on at the college, and it's sent to you, to each of you individually, okay? And then could be an email, right? And you read the document and you say, oh my God, I have questions about that. And so let's go to the next slide. So here you are, all 7 of you. I was alarmed by what I read in the bulletin, and I need more information. So you are now communicating back with the person who sent the email. And this could also be, by the way, this could be a series of meetings, like breakfast meetings that or Zoom meetings, where you have scheduled time with the superintendent president or other staff member to inform you about items that are coming up at an upcoming board meeting. So either way, this rule applies and allows each of these individual conversations to occur. Note that it doesn't say that 2 people can be getting the information at the same time. It does say separate and individual conversations. So when I'm asked on this, can 2 trustees be sitting in on the same meeting? I say technically no. And again, there's the rule, so long as the staff does not communicate comments or positions of the other members.
And if I can say, this is why when I send out questions that you may have regarding a board agenda, I never indicate who sent the questions, and I never even indicate who sent the questions to the staff who helps me answer them. I'm the only person who knows. Actually, that's not myself and the board chair are the only people who know who sent in the questions, and that's why you get them without any reference to who sent them and who answered them.
Aha, yes, and that's a common practice, is that when one trustee asks a good question, then the answers are provided to all trustees.
Mm-hmm. Yes.
And that's what we're referring to, and that's totally appropriate. Okay, next slide. All right, so what's going on here? Let's start in the middle. So let's just assume that we had that same Friday bulletin that went out that had talked about something important going on at the college. And it goes out in an email, and one trustee expresses their feelings and opinion, we'll call that discussion, in an email back to the staff member who sent it. So let's assume it's the superintendent president, sends out the bulletin, email, oh my goodness, I'm very concerned about this. We need to talk. This is blah, blah, blah. And they do it with a reply all, and it goes to all the other trustees. And so This is your typical serial meeting, even if trustees 2 through 7 are just reading the email and are not participating in it, because they all now know they're a party to this discussion. It's almost like they're listening to it happening without actually opening their mouths, right? And so we have a great way to avoid doing this. And I am curious if Superintendent President Andrew Jonas employs this. So what do you do? Oh, can't hear you. You're muted.
So what do? I immediately alert everyone through blind carbon that they need to that nobody should hit reply all, and just a gentle reminder that when you send emails, you need to use blind carbon because nobody should be replying. And when you do that, the only person who gets the reply is a single person.
That is exactly the best practice. So this need not happen. All right, next slide. Okay, so they took the concepts that we just went over, and at the end of last year, the legislature passed a new law because, you know, social media wasn't mentioned anywhere in the Brown Act. And so we, you know, of course, it's existed for many years, and we had to kind of guess what the rules were. And so the legislature did a favor and actually updated the Brown Act for modern times. And this is what, they didn't answer every question, but this is what they did. So they said that they defined, you know, much like that information gathering exception, they defined certain communications on social media not to be violations on the Brown Act, of the Brown Act. And so it was called AB 992, and it said that the members of the legislative body may engage in separate communications on an internet-based social media platform to answer questions. Okay, so this is really allowing trustees now to be out in the public, right? And this is more, you know, you're getting questions from your constituents on social media, and it's likely that all the trustees are, you know, friends or are connected to your social media outlet. And so the question was, is there a problem, you know, like in the previous slides, if they're just, you know, if they're getting the information too, if they're seeing you doing this, right? And we said in the previous example that, you know, that has to be a series of separate conversations. And that's not true for social media. Now you are explicitly allowed to answer questions, provide information to the public, or even solicit public input on matters within the body's jurisdiction. And you can do that on social media while, you know, all the other board members, the superintendent president, everybody is kind of seeing this happen. And so this kind of opens up and frees us up a little bit to not be as cautious. You should always be cautious in what you say on social media, right? But for the purpose of the Brown Act, you can answer questions that the public has and have other trustees see your answers, and you can provide information to the public. Now, you know, the extent to which we control information that is coming from trustees to the public is a whole different matter, right? And that has to do with your communications protocols and the training that you get on good boardsmanship and wanting to make sure that the board is acting as a unified body so that you do well in your accreditation scores. All those are separate issues to this, but this certainly talks about what the Brown Act says about your participation in social media. So now let's focus on what this new law said you can't do. Next slide. Aha, this is what you can't do, big red X. So similar to what we've talked about already, these concepts are very analogous to the previous slides on serial meetings. So it says a majority of the legislative body may not discuss among themselves business of a specific nature within the body's jurisdiction, which encompasses, okay, here we go. So discuss amongst themselves business of a specific nature is defined as being any communications made, posted, or shared on social media between members of the legislative body. Okay. So this is generally when you are you're doing something other than providing information or answering questions. You're actually dialoguing or discussing, probably in the first bullet here, with somebody who's not another trustee. Okay, it's a member of the public, and but the your communications with that person are being shared on social media, and there's members of the legislative body who are participating in that. And so this whole first section again talks about a majority of the legislative body. So if there's 4 or more trustees who are participating in this social media and have accounts, for instance, then then this is where the danger is in just going beyond answering questions and providing information, because it's likely that your discussion on social media will reach more than a majority of the board. So, and then also they were clear that you can't, it is a substantive comment if you are doing things like liking and doing emojis that show how you feel about stuff. So then individual, now this is where this new rule is stricter than what we normally would expect under the Brown Act. It actually says that individual trustees, not a majority, but individual trustees may not directly respond to made, posted, or shared by any other member of the same legislative body anytime, as long as it has to do with the subject matter jurisdiction. So that's pretty strict. You can't directly respond to other trustees on social media, not even one. Okay, so that's kind of new. All right, let's go to the next slide. Okay, so, and I'm going to plow through this rather quickly because this is the old stuff. And we need to make up a little bit of time here. So agenda, regular meeting agendas, we know they're posted 72 hours in a location freely accessible. They're also put on the website. Agenda descriptions for open session must just reasonably inform the public of the matters to be considered in sufficient detail for members of the public to determine whether to participate in the meeting. So that's the standard. We call it a brief general description. Next slide. Okay, special meetings are different from regular meetings because they can be called either by the president of the board or by a majority of the board, which is interesting. I've had that happen, which you obviously have to have a discussion amongst 4 board members in order for a majority to call a meeting, but we hope that the subject of that discussion has been limited to we need to call a special meeting, and this is the subject of it. Notice of a special meeting must be mailed or delivered to the media and posted not less than 24 hours. So obviously we do this by email these days. So it's a 24-hour rule rather than 72. The board can only consider business specified in the notice. There's no requirement to do general public comment, which is why at the meeting today, we just did comment on this, this item. And it is possible to meet in closed session as part of a special meeting. And one of the new rules is that you can't consider, compensation, amendments to contracts that have to do with salary or compensation, or even fringe benefits paid to any what's called a local agency executive, which is your superintendent president and likely the other cabinet level members. And so you always have to watch out when you're doing amendments to contracts and make sure those happen at a regular meeting. Okay, next. Public participation, members of the public must be able to address the board regarding items on the agenda before or during the governing board's consideration of the item. So that's the Brown Act standard. There is a separate community college standard in the education code, which takes this one step further and actually says that you're supposed to allow the public to comment on items as they are taken up in the meeting. But that's not a Brown Act requirement. I am aware of some community college districts that don't follow that, and there's not really a good way, somebody can complain about it, but it's not a Brown Act violation, so it's hard to enforce. Okay, next slide. Public participation. There is the general public participation, which allows an opportunity for people to talk about anything within the jurisdiction of the board. The board can adopt reasonable rules and regulations. As you have done so for COVID-19, we had to change all of our rules to allow for, email, email participation, Zoom participation. There was lots of variation there. The bottom line is that you can limit the number of minutes that somebody speaks, as long as if they need a translator, you give them double that amount. And you can limit the total time that you have for public comment. And you can also change that, meeting by meeting. If you have a meeting that has a especially, packed agenda and you don't have time for an hour of public comment, you can, in a particular meeting, adopt a rule to change those rules. So you have quite a bit of flexibility in adopting rules and regulation. But what you can't do is you can't adopt a regulation that prohibits public criticism. So the public is able to criticize public officials and, in fact, public employees. And we can't really stop them from doing so. Yes.
Todd, could you speak a little bit about if there's an instance where there are, let's say, 20 speakers who come to a board meeting all to talk about the same topic? Could you talk a little bit about the board's ability to limit, if they normally gave 3 minutes for public comment, how they are allowed to limit public comment on a single item?
Sure. Yeah, you can require people sign up in advance, right? And when you see 20 speakers, you can decide, okay, 20 speakers, well, everybody gets 1 minute rather than the normal 3. The Brown Act, you could have a rule that says, that we're, going to take, only 5 speakers pro and 5 speakers con on a particular business item. Normally that's not done, but it is possible to basically enforce rules that say, the public comment is getting repetitive. We've heard that already. Is there anybody that has something different that hasn't been said already? So those types of things are reasonable rules and regulations. Okay, next. Okay, this is one of the more important slides. I always say the board president should have this laminated, put a chain around it, and put it on your gavel. And because this regulates what trustees can do at a meeting, right? Particularly regarding when you have, stuff that's happening in your meeting, people speaking at the board that aren't on the agenda. Because it's the law, it's the Brown Act that trustees and staff, when people are bringing up stuff that's not on your business agenda, all you can do is briefly respond to statements made or questions posed by the person making the comment. So brief responses, no back and forth dialogue, doesn't turn into a debate and sidetrack your meeting. You can ask clarifying questions and make brief announcements. All this is best done by the board president, by the way, rather than having the cacophony of 7 board members all interacting with the public. Provide a reference to staff or other resources for factual information. Request staff to report back or place a matter on the agenda of a future meeting. That's it. Okay, so this is the authority of the board president when things are getting out of control and the board is interacting with the public to say, wait a second, the Brown Act doesn't allow us to do this. Gavel, bang, bang, bang.
And the superintendent president highly discourages responding to speakers because it is so hard to avoid that back and forth. Just saying.
Yeah.
Can I make a question comment for you?
Yes.
So many times when someone is addressing us, obviously about some concern that's going on at the college, and I would say probably 99% of the time, there is a process for that issue or complaint to be heard through the college system.
Mm-hmm.
And usually what happens is because we're so afraid to violate the Brown Act, nobody says anything except thank you. But in days of old, it used to be a standard practice that the superintendent or the board chair would address the point I just made, that there is a process, that, you know, we heard their comments and concerns, appreciate them talking to the board. There is a process. We want to make sure that they know how that process plays out, that they can take that to the next appropriate level so that their concern is dealt with, and eventually it may or may not, if not resolved, end up back here at the board. And I think it's important to the extent that we can say that under briefly respond to statements, that we identify to speakers and future speakers that are thinking about being speakers that, you know, there is a process. It's not that we're not listening, but you got to follow the process. And so I kind of like with your guided counsel, maybe if fellow trustees agree with me and or superintendent, that we could have such a brief statement that's our kind of standard go-to statement, so it doesn't look like we're all just sitting up there totally falling asleep and not responsive.
Well,
So
my concern about it is that sometimes, a lot of times, the individual has already been through whatever that process is. And you know, I think back to some sticky issues we had over the last couple of years, and some individuals who came to give public comment did not tell you the truth. They were not honest in what they said. And they were not honest about whether or not they had had an opportunity to go through a process. And and what I can tell you is that individuals on my staff reached out to those individuals. And in this case, it was when we were still face-to-face, and they walked over and started talking to them, offered them a business card and said, here, we'll follow up. But
so I'd like to address this to the council, if I may, Erica.
Yeah, okay,
Because as a trustee, I feel like we are perceived to be not doing our duty. And maybe I didn't articulate the comment correctly as I laid it out, but what I was trying to articulate to the public in general, to that person, but to the public in general, is it's not that we're not responsive. There's a proper way to address this, and we want to make sure you're addressing it properly and it's being addressed properly. And we'd like you to follow that process. And if you don't know what it is, there was usually somebody we could even refer them to go talk to at the meeting afterwards or something to know what that process is. And it's the same generic sentence you say to every single complaint. When somebody has a complaint, that's kind of like a complaint. Sometimes, you know,
So
we
John,
want you to, you know, that. So,
John, would you have us say that even if, as Erica said, that person has already gone through the process? And
well, let's think about that, because the process ends with the board under formal request. So if they had properly gone through the process, they would have made a formal request to address the board. It would have been agendized, and we would have talked about it in the appropriate way. And we've done that on rare occasion. So they haven't really gone through the process, even if they've gone through many of the steps of the process. So if they don't want to take that official filing of complaint with the board, that's up to them. It's fine. But the generic statement, the way I said it, was just basically saying out to people, it's not that by us not responding, we are not concerned. It's just there is a proper way to deal with this, and we have to ask you to follow that process.
Yeah.
If
think
you're
I can
not sure what
respond.
it is, there's somebody that can direct you to help you know what that is.
Yeah. Why don't I respond? Because I attend a lot of meetings of different boards. And I would say that the normal practice is for trustees to nod and basically I've heard you. So that is more the norm than to have a, interaction with the people who are publicly commenting. I do think it's the role as superintendent president. If there is someone who's publicly commenting and obviously they haven't gone through the right process, and there is a complaint process or a procedure that they can be guided to, that would be the superintendent president would jump in at that point and say, we do have a process to address your issue. But lots of times the person who's speaking to you is already known by administration, and what we don't want is administration to get into a public explanation with the board about why this person shouldn't have why this person is upset, I guess. So it's very dangerous to expect all people who come to you complaining about process to be given some sort of guidance, because we don't want this to degenerate into anything more than these 4 bullet items, and that's what it will. It'll turn into an argument basically between staff and the person who's speaking, and that's the danger of it. So I know it's uncomfortable sometimes to sit as a trustee and just nod and feel like we're not helping this person. But I think you have to trust your administration that a lot of the people that are coming to speak before you can't possibly know all the background of what's going on. And some people help, and some people.
I totally agree with that, and I don't. So I'm going to take one more poke at this cow, and you can just say that you can cut me off then. But this is my one chance to kind of really get this to what I'm thinking. So the sentence that I was attempting to dictate ended with, and if you're not clear with that process, you can talk to fill in the blank after the meeting. And there's no dialogue back and forth. It's over. We got a process for this. You need to follow it. If you're not clear what it is, we want to help you, and you talk to this person after the meeting.
Exactly. That's really the third bullet. That's the third bullet. And that should happen sometimes, but it won't happen every time.
That response at least says to the public that it's not like we're not up here without any concern for you. We do have concern for you, but then, and I don't mind if the superintendent's the one that says it. I don't mind who says it. I don't care.
Yeah, because the superintendent president will be in the best position to know if this is somebody who can be helped, or if there's somebody that's already been through the process. Doesn't like the result.
It doesn't have to come from me or the chair. I don't care. I just want that. I want that person and the public to know that there's a process and we follow it. Appreciate your thoughts. There's a process to deal with this. We will, and if you aren't sure what that process is, talk with so-and-so after the meeting and we'll make sure you understand. And that says to the public, we take care of business.
So I have a take on that. I pretty much disagree with what Trustee Martin is saying, only because I definitely know that most folks, when they come to the board meeting, they have already been through the process, just like Trustee Silver said. I know that's what they have. They probably already interacted with the superintendent, her staff, and all these others. So repeating that just for us to feel good that we're saying something, it is. I know it's a little uncomfortable, but they already know what the process is. They've been through it. And they probably don't even want to hear from Dr. Andrew Jones, and because what they're hoping is that the trustee will throw all that to the back and change stuff. So no, I think we should just follow these 4 bullet points and have them go away.
And so because I don't usually say too much, I'm going to hang in here one more time with your permission, Chair Brown.
Go ahead.
I'm obviously not believing that there isn't some wisdom or discretion as to when to drop the sentence. So you have an issue, it's been settled, it's over and done, and somebody's just up to complain that they didn't like the way it went. This sentence does not apply. I mean, you know, let's use, our superintendent has enough. I'm trying to put an arrow in the quiver that can be used at the right time and many times for the betterment of the public. I don't believe it's a universal arrow. So, you know, there may be quite a few times where you don't use it. Okay. So, and we've had places where we've had the same person back, you know, 5 times in a row, 5 meetings in a row, and they're going to keep saying the same thing 5 times in a row. Okay, well, you know, there's no use, you know, I'm not trying to say we universally pull out this arrow and shoot it. But I do think there is many a time where the public and the general public that's watching needs to know there's a process, and we're going to help you follow it.
Yeah,
that's my point.
It is a tool that can be used, and it's covered in the 3rd bullet.
Yeah, and I don't mind the trustees keep their lips sealed and can shake their head whatever direction they want, and the superintendent is the one that fires it. But I can, without getting specific, as you warned us not to do, there's been numerous cases during the last couple of years where I just wish somebody would have shot the arrow at the person and said, hey, there's a process for this. You don't need to keep doing this. Follow the process. Eventually it ends up with a formal appeal to the board. Okay, fine. All right.
Okay, next slide. All right, so under COVID, real quick, the important executive order was this one that went down on March 17th. As we know, it suspended the Brown Act requirements to allow members of the public to attend the meeting in person and authorized you to hold Zoom meetings. And you might remember very briefly, the order said that you needed to provide a physical location from which members of the public could observe the meeting and offer public comment. That lasted about 5 days or 3 days, and it got taken out. And so there was no requirement to do that about 5 days after the initial announcement of this. So next slide. Okay. Minutes. There's very little to be said in the Brown Act about minutes. That's basically in the Ed Code, and it says the minutes are public records, and it just says you record all actions taken. So I don't want to get into a big dialogue about this, but sometimes boards get into real disputes about what is said in the minutes, and that's just totally really not regulated by the Brown Act. No action can be taken by secret ballot, almost goes without saying. This was a change from a couple years ago. The board has to publicly report, not out of closed session, but when you're voting in open session as well, any action taken and the vote and abstention of that action of each trustee present for the action. So you are supposed to be recording your votes that happen even in open session by indicating the name of every member that voted. And you can still do a voice vote where everybody votes aye, but it should be recorded, not 7-0, but with the names of the trustees, because you're supposed to be able to go back and see how everybody voted. And when it just says numbers 6-1 or 5-2, that doesn't give us enough information. And people have a right to record the meeting. They often do that no longer with the big video cameras, but with their phones, as long as they're not disruptive. Next slide. Closed session, we could go on at length about closed session. We're not going to in the interest of time, and it's actually not even, took out a lot of slides here, but there are limited authorizations for closed session. The ones most common are the talking with the lawyer about legal litigation, discussions with the labor negotiator about pending labor negotiations, discussions over real property, student matters, and the most common one, individual personnel matters, and it's in closed session to protect the privacy of the employee involved. So next. So the agendas, the Brown Act does describe with particularity what you have to say on your agenda for a closed session item. And so there's a lot of effort goes into in the superintendent president's office with their executive assistant to make sure that this is all done right. And there's what are known as the safe harbor agenda descriptions, which are written right into the Brown Act. And we're going to just see a couple of those now. Next. Okay, so the conference with labor negotiator, you have to list the local agency negotiators, and that could be an assistant superintendent. It doesn't need to be an outside negotiator. The represented parties, the names of the unions, and then sometimes you're negotiating, say, terms of a renewal of a contract with the superintendent president or with another contract administrator. And so unrepresented parties, when you're discussing what their contract might look like, not with them, by the way, but amongst yourselves and oftentimes the board president is designated the labor negotiator in those situations. So you can basically, as a board, give parameters as to what you would support and what you wouldn't support in negotiations that aren't collective bargaining negotiations, but rather renewal of contract type negotiations. Conference with legal counsel. Existing litigation, you have to actually say the name of the case. You can't just say a number there. Public employee discipline, dismissal, release. Nothing else is required there. But what's important is that you have to be discussing somebody in particular. And it doesn't necessarily have to mean that the discipline, dismissal, or release is imminent. Oftentimes we're briefing the board on investigations into potential misconduct that could lead to public employee discipline, dismissal, release, and all that is authorized under the closed session authorization that protects personnel privacy. And public employee performance evaluation is similar but different. You are required to specify the title of the employee being reviewed, and that doesn't necessarily mean just situations where you are doing a formal evaluation. Oftentimes, I know some districts that have evaluation of the superintendent president as a recurring item. And the law, in this case, has broadened this authorization to allow you to discuss any performance issues, positive or negative, with your any employee, as long as you specify the title. And so it doesn't have to be part of a formal evaluation. Next. There is a requirement to sometimes report out information out of closed session. There's quite a bit of the time where you're not going to report anything out. So you do have to report out. And reporting out is you have to reconvene an open session. So even if you don't have anything to report out, you come out of closed session, especially if it's at the end of your meeting, and you have to meet in open session to adjourn. And so it's at that time that you would report out. If you hold closed session at the beginning of the meeting, usually you report out when you come into open session, or you say there is nothing to report out. Law says you can do it orally or in writing. It's almost always done orally. Any documents referred to in a report of final action must be made available to any person on the next business day following the meeting in which the action is taken. And in the case of substantial amendments, when the rewriting is complete. So if you approve a settlement agreement or something, it needs to be made available the next business day. If an individual has made a standing request or requests documents within 24 hours of the agenda being posted, the documents must be provided when the closed session ends. So for those people, in this particular, your student journalists, if you approve an agreement, they're supposed to, and they're on the list of people that gets the regular requests for documents and agendas, then you need to give the agreement to them at that meeting. Okay, next. All right, we're getting close. We're at the 5-minute mark. So let's just review some of the Brown Act changes under COVID-19. Next. So as we previously mentioned, the March 17 order was the big one that suspended the requirement for physical presence at meetings. And the next slide will talk about all those rules that were relaxed that allows us to do Zoom meetings. There was another executive board order that didn't apply very often, but there was some thought that there should be more flexibility for trustees to receive informational updates. And so the executive order said that you could get those, and but you still couldn't discuss or take action by a majority of the board outside of a public meeting. I think you probably could have done this already without the executive order, but in any event, that happened. So next slide. Okay, so here were the suspended Brown Act provisions that we'll see how many of these will go back and that we'll have to comply with in the future. This is where I was saying earlier, I hope some of these stay. So to do teleconference meetings, which we understand to be Zoom meetings now, you used to have to put a notice, an agenda at each location, like at each of your houses, if that's where you're at right now, and you don't have to do that. Your houses and places that you're attending these meetings from do not need to be accessible to the public and ADA compliant. And members of the public, don't have a right to address folks from your house. And the requirement that at least one member, these last two bullets were, a lot of people didn't know these were even existed, but the requirement of at least one member of the legislative body being physically present at the meeting location, that doesn't apply now. And the requirement that during a teleconference meeting, at least a quorum of the legislative body participate from locations within the boundaries of the district. So the rule used to be you had to have 4 people, and even if 3 of the 4, you got your one person in person, and you could have 3 people, remote, as long as they were all like at their houses within the jurisdiction of the community college district. And it may be something like that probably may very well continue to be relaxed to allow greater Zoom participation by trustees.
Wait, I have a question on that. So does that mean I could Zoom into a board meeting if I were out of state?
Absolutely, yeah. And somebody said earlier you can't Zoom in from Italy. Well, I've had people Zoom in from. It might be impractical for someone to be at their physical location, but as long as you comply with these requirements, you can be anywhere in the world and participate. So, yeah, as long as there are 4 board members within the jurisdiction of the district, even at remote locations in normal times, pre-COVID and post-COVID, that's still lawful. One person in the physical location, at least 3 people within the district remote, and then the other 3 could be, in foreign countries or other states.
But is there a requirement that the public be notified that not everyone is going to be there, that they're going to be in other locations?
Yes, that requirement, that's the first bullet, is the requirement to notice each teleconference location from which members of the legislative body participate. I didn't quite say that. I said,
yeah, I wanted to make sure.
Yeah, it's actually the rule applies both places. See, at the district, the agenda that covers the district office has to say where everybody is, and then the notice also needs to be posted at the remote location.
Wait, I thought these were suspended.
They are suspended, but when June comes around, they're going to all snap back when the governor lifts the executive orders.
Todd, there is a bill going. It's Assemblywoman Rubio has a bill that's going through the process this week, and this is coming back, but you have to be in your jurisdiction. You can't be in another country or state.
Yeah, so it'll be interesting to see how that changes the existing rules. If that, I would be surprised if it says that you absolutely can't be in another state, because you can right now.
Yeah.
Yeah.
Well, I was in a situation where a trustee was in a board committee. This is not in this district. Was in a board committee, but attended it telephonically. But there was no notification to the public that only one board member was going to be present and the other one was going to be telephonic. So there was no indication that that board member was going to be in another location. So it completely negated the decisions that were made that day, and the committee had to meet again.
Terrible. Yeah. And in, you know,
But
the normal
Erica,
rules.
if I could interrupt, Erica, in that example, if there
Mhm.
were only 2 people on that particular committee, what decisions were they able to make anyway without full board vote in that particular example?
It was a 5-member, it's a 5-member board. And there were 2 out of 3 committee members present. And the committee decided to make a recommendation and send it forward to the full board, even though they only had 2 members there. The problem was one of the members was telephonic and the other one wasn't, and one was missing.
And so in that example, a recommendation by a committee to the full board, that's still a vote for these purposes that we're talking about?
Well, in this case, it had to do with, it was a personnel. It had to do with changing a job title and for somebody who was actually in the position. And it was like, it involved restructuring something that the board was going to have to agree to, but because they only had 2 people out of 3 and one wasn't even in the room, and it wasn't properly noticed that that person was not going to be in the room, it negated the meeting. So it's like it never happened.
Yeah, you'd have to do a do-over.
Yeah, it was a do-over.
That's not terrible.
It's not terrible. It's not terrible. It's just inefficient and not great.
Okay, so the last point I was going to make is the most common problem is board members that decide at the last minute that they can't make the meeting. Note that in normal times, we have to know where, not only that you're not going to be there, but where you're going to be 72 hours in advance so we can put it on the agenda. And so with that, I understand that our time limit is up, and I hope this has been informative. And
can I ask you a question before you go?
Sure.
This deals with closed session. I'm very a stickler that people should not talk when things are said in closed session after the meeting. And I'm involved in something right now where it's a big GM position. I'm on the panel, and I got calls from city councilmen in LA urging me to vote for this person. And these names were not even supposed to be out there. And I'm sorry to say, on this board, not the current board, but when I got here, there was some information that went out on closed session with one of our hires. And have there ever been significant court cases dealing with this, or indictments or anything dealing with people releasing information in closed session?
Yeah, unfortunately, I'm not aware of any criminal activity. They always say that the number of times people have been criminally prosecuted under the Brown Act is you can count them on one hand. And so what happens is, the revealing of closed session information, normally because you don't have an outside agency that can police that, the board polices itself. And if you can, as we know, the harshest act that a board can take to discipline a member who, say, violates the Brown Act is a censure, which is just a public reproval of the behavior. But with the revealing of closed session confidentiality, I mean, we can say it is in the Brown Act. I mean, you are violating the law when you do it. And, I'm, as a lawyer who is in a lot of closed sessions, many times I will give that admonition of saying it is in the interest of this institution that you took an oath and swore that you were going to take all the actions in the best interest of this institution. And it is not in the institution's best interest to reveal closed session confidentiality. And in fact, you'll harm the district's interest if you do so in this particular legal matter. And so I want to say that closed session confidentiality is the law. It's extremely important to the institution, and that it's important that each member comply with that. But if they don't, the chance of the DA prosecuting is not very great.
Yeah, that's the problem. Yeah, thank you.
You're welcome. All right, are there any other questions?
I have a question.
I have a question about social activities. It sounds to me like I could, for example, invite the board to my home for a summer barbecue, and they could all come as long as conversation was only about movies and books and music and restaurants and did not touch PCC business. Is that correct?
That is absolutely correct. And actually, let's advance the slide one because we'll get to question time. So yes, you are exactly right. The rule is that 7 members of the board can gather, socialize, as long as you don't discuss the business of the community college district.
And then on the flip side, suppose next year it's a graduation and we're all together and we're so proud of our students. We cannot start chit-chatting like, oh, we've done so well with our graduation. We've really improved our student outcomes. Like, we can't talk about that then, technically, correct?
Yeah, you shouldn't be doing that at the graduation. That's another exception that allows you to attend ceremonial events such as graduation, such as groundbreakings, things like that.
Right, but just hold that conversation aside.
Right, you should.
Yeah.
Okay.
Todd, I have one clarification.
Okay.
So I know you're not supposed to give examples, but so if you're at a community meeting, like I hosted a community meeting, and if there are, 4 board members from another district attending, and it's not about the business of that district, but more about just general topics like the budget or things like that, can they attend, or is that, or can we attend, meetings like that if, 3 of my colleagues are going as well?
Yeah, there's special rules. I didn't cover all that. That was one of the things I cut out. But as long as the meetings are advertised as open to the public, if it's a community meeting, then more than a majority of the board can attend that community meeting. But again, you just can't discuss business related to the community college district of a specific nature. But you can attend. There's not a problem attending.
Great, thank you.
It's an open meeting. Mm-hmm. It doesn't have to be a Brown Act meeting, by the way. It can just be a community meeting. Great. Okay. Well, we've had a great afternoon together. I enjoyed it very much, and I hope you got a lot out of this. Any final words, Superintendent Andrew Jonas?
No, just thank you for doing the training. And I think it was really enlightening and helpful. And, the best board in the world is the best trained board in the world. So thank you for helping keep this board the best board in the world.
Yeah, absolutely. It was good to get the updated information. Thanks, Todd.
Yeah.
Thank you, Todd.
Thank you. I've attended a number of these, and every time I go, I learn something. And this particular one, I learned a lot about COVID protocols, and it will be interesting to see as we go back to live meetings if we can peel back some of those, and allow more of this telephonic participation.
Yeah, because it's worked. I've attended I've attended more Zoom meetings than I ever did in person. And I think the public also appreciates it because you can attend meetings from your house. And we've had, in many districts, have the participation of the public go way up from our normal standards.
Yeah, agreed. Zoom meetings are actually much more open meetings and much more public oversight, attendance.
Mm-hmm.
Yeah.
Yeah, I think it's been good.
Yeah, thank you. And give our thanks to Warren too.
I will.
Okay.
Yes.
Thank you.
Thank you, Todd.
All right. Goodbye,
Thank
everyone.
you.
Bye.
Arrivederci.
So do we have anything else?
Arrivederci. What,
So,
Berlinda?
do we have
Berlinda?
anything else on the agenda?
When's Tammy's party?
Oh, party, what pen? So are we adjourning at this point? Because I don't
There,
think there's
the
anything.
agenda is complete. You're good.
Where you going? Where you going, Berlinda?
Huh?
You have to go? Do you have to go?
Yeah, I do. I have a life. Okay, you guys, thanks again. Have a great day.
Okay, bye.